The courtroom, a place of high stakes, where justice is meant to be blind. But judges are human, they possess the same inherent biases as anyone else. These biases, often unconscious, can seep into decision-making, influencing verdicts. Understanding these hidden forces within ourselves is not about undermining the legal system, it's about strengthening it by recognizing how cognitive biases impact judicial decisions. We can begin to safeguard against their influence. This journey into the mind is about empowering ourselves to be more aware, discerning, and just in all aspects of our lives. Cognitive biases are like mental shortcuts, often helpful in everyday life but potentially dangerous in a legal setting. One such shortcut is confirmation bias. We latch on to information confirming our existing beliefs while dismissing contradictory evidence. Imagine a judge predisposed to believing certain types of defendants are more likely to be guilty. This bias might lead them to interpret evidence in a way that confirms this preconception. Another potent bias is the anchoring effect. The first piece of information we receive acts as an anchor, influencing our subsequent judgments. If a prosecutor demands a harsh sentence at the outset, it might unconsciously sway the judge's final decision. Recognizing these biases is the first step towards mitigating their impact. This awareness is vital not only for lawyers, but for anyone interacting with the legal system. Confirmation bias isn't about intentional prejudice. It's about the invisible filters our minds create based on our experiences and beliefs. Imagine a judge presiding over a case involving a corporate crime. If that judge has a history of personal negative experiences with corporations, they might unconsciously seek out information confirming that bias. This doesn't mean the judge is deliberately unfair. It means their pre-existing beliefs are acting like a lens, distorting their perception of the case. Jurors, too, can fall prey to confirmation bias. They might have preconceived notions about the type of person who commits a certain crime. Awareness is the first line of defense. By recognizing our own potential for confirmation bias, we can start to question our assumptions and actively seek out alternative perspectives. The anchoring effect highlights the power of first impressions. Our minds tend to latch onto the first piece of information we receive, using it as a reference point for all subsequent judgments. In a legal context, this can have a significant impact on sentencing, settlements, and even jury deliberations. Imagine a prosecutor in their opening statement demanding a hefty 20-year sentence for a particular crime. This initial number acts as an anchor, influencing the judge's perception of what a reasonable sentence might be. Even if the defense presents compelling arguments for leniency, the judge's final decision might still be influenced by that initial high anchor. Understanding the anchoring effect is crucial for legal professionals. By controlling the narrative and setting the stage with persuasive opening statements, lawyers can potentially influence the way evidence is interpreted and judgments are made. The availability heuristic is a mental shortcut where we judge the likelihood of an event based on how easily we can recall similar instances. The problem is, our recall isn't always accurate. We are more likely to remember events that are vivid, emotional, or widely publicized, regardless of their actual probability. In the legal system, this can lead to distorted judgments. Imagine a jury deliberating a case involving a rare but highly publicized crime. The media frenzy surrounding the crime might make it seem more common than it is, influencing the jury's perception of the defendant's guilt. Combating this bias requires a conscious effort to rely on statistics and factual data rather than anecdotal evidence or emotional appeals. Lawyers need to be prepared to counter exaggerated claims or sensationalized media portrayals with objective information. By promoting a fact-based approach, legal professionals can help ensure that justice is served based on evidence, not on distorted perceptions of reality. We are hardwired for stories. They captivate our imagination, engage our emotions, and stay with us long after facts and figures fade away. In the courtroom, storytelling can be a lawyer's most powerful tool. Imagine a defense attorney representing a young man accused of theft. Instead of simply stating the facts, the attorney could weave a narrative. They could describe the young man's upbringing, his dreams of providing for his family, and the moment of desperation that led to his lapse in judgment. This story, while grounded in truth, paints a picture in the jury's minds. They are no longer evaluating a case solely on legal technicalities. They are connecting with a human being, feeling empathy for his struggles, and understanding the context of his actions. A compelling story can be the difference between a guilty verdict and a second chance. Repetition and priming. Planting seeds of persuasion. Repetition in the right hands is not simply redundant. It's strategic reinforcement. It's about subtly embedding an idea in the minds of the jury, making it feel familiar, believable, and ultimately persuasive. For example, if a lawyer consistently uses the phrase self-defense when describing their client's actions, the jury becomes primed to associate the defendant with that concept. This isn't about manipulating the jury, it's about reinforcing a key aspect of the case. Overdoing it can backfire, sounding like a broken record and losing the jury's attention. The key is to integrate key words and phrases naturally into the flow of the argument. In the courtroom, as in life, perception is everything. Two lawyers can present the same set of facts, but the way they frame those facts can drastically influence the jury's interpretation. This is where the power of contrast and framing come into play. Contrast involves juxtaposing two opposing ideas or scenarios to highlight the differences between them. For example, if the prosecution is seeking a harsh sentence, the defense attorney might contrast this with the lenient sentences given in similar cases. Framing, on the other hand, involves presenting information in a way that influences how it's perceived. The way a lawyer frames the evidence, the words they choose, and the comparisons they draw can subtly shape the jury hadatik's understanding of the case. It's about presenting the truth in a light that favors their client's position. Let's enter the world of criminal defense. Our client, a young woman named Sarah, is accused of embezzling funds from her employer. The prosecution's case hinges on circumstantial evidence. Sarah's access to the accounts, her recent financial difficulties, and a witness who claims to have overheard her discussing financial misdeeds. The judge, having presided over numerous white-collar crime cases, might be susceptible to confirmation bias. Sarah's defense attorney, however, is prepared. They understand that the first battle is against the judge's potential preconceptions. Instead of waiting to present their case, the defense starts strong, immediately addressing the elephant in the room, Sarah's financial struggles. They present evidence of Sarah seeking legal financial advice, demonstrating her attempts to address her situation through legitimate means. This strategy directly combats confirmation bias. By proactively presenting evidence that challenges a stereotype, the defense attorney disrupts the judge's potential bias from the outset. Imagine a courtroom buzzing with anticipation. A young man, Michael, has been found guilty of a drug-related offense. The prosecution, aiming for a strong deterrent sentence, argues for the maximum penalty 10 years. This number, boldly stated, hangs in the air, becoming the anchor in the judge's mind. Michael's defense attorney, however, understands the subtle power of anchors. Before the prosecution can cement that 10-year figure in the judge's mind, they offer an alternative, a rehabilitative sentence focusing on counseling, community service, and a chance for Michael to turn his life around. By introducing this alternative sentence early on, the defense attorney shifts the anchor. The defense has successfully disrupted the anchoring effect, paving the way for a more just and compassionate outcome. The grand halls of the appellate court echo with history. Here, legal precedent holds immense weight, often dictating the outcome of cases based on past rulings. But what happens when precedent, once a beacon of fairness, becomes a barrier to justice? Consider a case involving employment discrimination. A group of employees is suing their company for discriminatory hiring practices that disproportionately disadvantage a particular minority group. The company, however, argues that their hiring practices are consistent with industry standards and past legal precedent. Judges are often hesitant to overturn established precedent, fearing that it might disrupt the stability and predictability of the legal system. To overcome this bias, the attorney must present a compelling argument that demonstrates its inadequacy in the face of evolving societal standards. By framing their argument as a natural progression towards a more just and equitable legal landscape, the attorney increases their chances of success. Section 4. The ethical tightrope: using psychological tactics responsibly. Psychological tactics in the courtroom are a double-edged sword. They can help lawyers connect with juries and advocate effectively. But if used unethically, they can distort the truth and mislead the jury. Legal professionals must adhere to the highest ethical standards. The goal should be to present a compelling and truthful narrative. When used responsibly, these tactics can level the playing field. They ensure a fair shot at justice for everyone. The responsibility rests on legal professionals to prioritize justice. Awareness as a tool for justice. We've uncovered hidden forces shaping judicial decisions. Cognitive biases can influence perceptions of guilt and innocence. This isn't about undermining the legal system, but strengthening it. Understanding bias helps safeguard against its influence. Legal professionals must understand the human mind for fair justice. These strategies ensure the truth resonates with human experience. The courtroom is a human arena filled with emotions and preconceptions. Legal professionals can become more effective advocates for justice. Section 2. Beyond the courtroom. Cognitive biases in our daily lives. Cognitive biases don't simply disappear when we leave the realm of law. They influence our decisions, relationships, and interactions with the world around us. Recognizing our own potential for bias is a step towards personal growth. Awareness of cognitive biases can help us navigate human interaction with greater clarity. Ask yourself, is my judgment being clouded by a cognitive bias? This self-reflection is key to personal growth and ethical decision-making.